In the Superior Court, Fulton County, Diamante Kendrick, petitioner versus Chief Judge Glanville, respondent. Diamante Kendrick's verified emergency petition for writ of mandamus. Comes now. Diamante Kendrick, through his undersigned counsel, and brings this emergency petition for writ of mandamus, showing as follows. Quote, this is a quote. Even if a judge did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interest and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. Inquiry concerning Judge Christina Peterson. This emergency petition is brought under the guidance from the Supreme Court of Georgia following rejection of a similar petition by that court. As explained by the court, in anticipation of the present petition, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal the final decision. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or orders of the judge. That is important because Judge Glanville is using that as a scapegoat for denying the motion. By claiming, oh, you don't like my rulings, so you do this. No, it has nothing to do with your rulings. They have said so, but you keep going with that excuse because you don't want to be excused from ruling on this because you are morally and judiciary corrupt. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective movements. Likewise, Chief Judge Glanville has denied the movement's respective request for a certificate of immediate review 3 times. A certificate of immediate review is the judge allowing them, the defense, to appeal that decision during trial. Judge Glanville is trying his absolute hardest to have every appeal after the trial. Chief Judge Glanville has obstructed the defense counsel's attempt to have a disinterested party review the numerous allegations contained in at least 4 affidavits, which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Chief Judge Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County's Sheriff's Office. As a result of the proceeding, on June 12, 2024, petitioner requested that the presiding judge, Chief Judge Glanville, recuse himself from petitioner's trial for, among other counts. Yeah, this is the count that we are covering right now, the murder of Donovan Thomas. Despite proceeding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25.3. Chief Judge Glanville denied a request for a certificate of immediate review. A former order denying the motion was entered on June 14th, 2 days after a motion for recusal was filed. Emergency relief is requested because the witness that was coerced by Chief Judge Glanville is presently on the witness stand. Absent emergency relief in some form, Chief Judge Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as coercive joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Chief Judge Glanville may make during the counsel's cross-examination of Copeland. This question here from Samantha Yo. Why not just send off the requests instead of holding them for after the trial is over? What's his motivation? His motivation, I would assume, is that he wants to see all of these people convicted and then lean back. And even if it's reversed on appeal, they will at least spend 5 to 10 years in prison. Some of them cannot afford the appeal. So it's a money issue as well for the defense. Most of these, I believe, the only person who can afford to appeal any conviction in this RICO case is Mr. Williams. None of the others. So it is genuinely unfair. As Glanville has found Petition's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests a writ directing Chief Judge Glanville to adhere to 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. Petitioner further asks this court for a writ ordering Chief Judge Glanville to produce immediately, and certainly no later than prior to the start of cross-examination of Copeland, an unredacted transcript to defendants of the secret ex parte meeting proceeding held on June 10th. Statement of facts. Procedural history. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State versus Diamante Kendrick et al. Now, this might seem weird to you. What do you mean, January 2023, nearly 18 months ago? A trial starts officially when jury selection begins. That is 18 months ago. Jury selection took more than 10 months, with trial before the selected jury beginning November 2023. Following the secret ex parte proceeding, June 10th, petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12th. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied in stanter, with a formal order issued on June 14th, 2024. Following denial of Kendrick's motion to recuse, Kendrick filed an emergency petition for writ of mandamus to the Supreme Court of Georgia on June 20th. The petition was denied due to Kendrick's not seeking initial mandamus relief in Fulton County. Yeah, we went through that earlier, I believe, or did I do it in a separate video? Never mind. The court noted that initial mandamus relief in Fulton County would not be heard by Chief Judge Glanville, as he would be disqualified, so seeking relief in Fulton County would not necessarily be futile. Thus, per the court's guidance, Kendrick brings the present petition. B. The secret ex parte proceeding. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants, is Mr. Kenneth Copeland. On Friday, June 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarcerated by Chief Judge Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned on court on Monday, June 10th, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of defense counsel, an ex parte proceeding was held in Chief Judge Glanville's chambers on June 10th. Among the attendees was Chief Judge Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Miss Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of that trial. Neither Chief Judge Glanville nor any member of court staff nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. One or more members of the defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland. Yes, remember this, because this is really important for the success of this writ of mandamus. He was already sworn in. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Chief Judge Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Chief Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. ADA Lover Hilton informed Copeland that there were over a dozen defendants left to try. Following the above coercive actions by Chief Judge Glanville, working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief still, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. That, in my opinion, should render her without a job. You can't do this. You can't do this. You cannot give immunity for perjury. You can't. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr., important Brady material that has yet to be provided to Kendrick. Yeah. In response to sworn witness Copeland stating to Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. Yeah, so Hilton was prepared to give him immunity, except for the things that would speak against the prosecution. I mean, this, if true, she should never practice law ever again. These troubling facts not only implicate Chief Judge Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through a counsel, filed a motion to quash, order to show cause, a motion to recuse on Friday, June 14th, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus' first-hand account of the misconduct is credible. The facts, Attorney Bumpus asserts, are as follows. On Monday, June 10th, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Kayla Bumpus, was escorted to the court's chambers and conducted an ex parte proceeding regarding whether Copeland would testify. Those present for the substantive portion of the ex parte proceeding were Chief Judge Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. Yeah, and then they go through all of that, which we just heard. Events in court about the time of the secret ex parte proceeding. On Monday, June 10th, all defense counsel were present in the Fulton County courthouse at or around 8:30 a.m. Admitted entrance into the courtroom 1C and seated within by 9 a.m. Exhibit A. Weinstein affidavit. Defense counsel waited and waited Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Chief Judge Glanville about the reason for delay, providing Chief Judge Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Chief Judge Glanville obstructed Steele's attempts to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Chief Judge Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge his information, citing Rule 1.6 of the Rules of Professional Conduct, Chief Judge Glanville held Steele in criminal contempt and sentenced him for 20 days of incarceration. Now, that was the short version. In that short version, we also have Judge Glanville not knowing the difference between civil contempt and criminal contempt, where he tried to coerce Mr. Steele into revealing his source. That's the civil contempt. Criminal contempt, you don't do what the judge says, you get directed to sentencing. More or less. That's the short. That's the short version of the thing that's not in here. D. Glanville's hearing on the motion to recuse and subsequent order. On June 12th, 2024, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings, which we know is false. That is Judge Glanville lying to the court. Chief Judge Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10th, 2024 secret ex parte proceeding was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing, and 2, in violation of Rule 211A in the revised Georgia Code of Judicial Conduct that says generally that, quote, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. I've been questioning in Judge Glanville's impartiality more or less from the get-go in this trial. Judge Glanville, during the June 12th, the hearing on the motion to recuse, Chief Judge Glanville refused to conduct the timely analysis required by 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Weinstein requested at the time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Chief Judge Glanville's ruling. Judge Glanville stated that an appeals court could look at his denial at the conclusion of trial, which is Judge Glanville. It's his way of saying, I don't care. I'm going to allow this trial to continue. I'm going to see that you get convicted and then, spend a few $1 million on the appeal. On June 14th, Chief Judge Glanville issued an order of motion to Chief Judge Glanville issued an order on motion to recuse Chief Judge Glanville. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by 25.3. The court found all 3 prongs of 25.3 satisfied, and the analysis should have stopped there. But Glanville did not. Applying the wrong standard and reaching the wrong conclusion, Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of the motion contains assertions of facts to support allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegation against Judge Glanville, there is a notable lack of evidence to support the assertion. This was the first of 3 motions to recuse denied by Chief Judge Glanville. Here's the thing. if the 3 prongs are considered done, he is not the person to do a finding of the validity of those allegations. That is for another judge. Argument and citations to authority. Standards for granting writ of mandamus. OCGA, this one, allows parties to seek mandamus to compel a due performance of official duties where a defect of legal justice would ensure from a failure to perform or from improper performance. And there is no other specific legal remedy for the legal rights. To compel removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. This is what Judge Glanville desperately don't want to allow. Hi, Brandon. Where was I? Yeah. This is what Judge Glanville desperately wants to avoid. Another judge making a ruling, because that means he is no longer in control. And he might be comfortable in risking his bar license, his future as a judge. Another judge might not be that stupid. To preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. Glanville has failed to follow the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavits are legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. Glanville, following filing and presentment of the motion to recuse on June 12th, to make the required determinations. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court, instead of recognizing it as a list of incidents of judicial misconduct by Chief Judge Glanville. Chief Judge Glanville curiously clings to Baptiste v. Tate as supporting his contention that the Weinstein affidavit does not merit recusal, but there is no support in Baptiste for this position. In fact, Baptiste supports Petitioner's position that Glanville's bias is of such nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. This is not the first time in this trial this judge has presented case law and been completely wrong about it. Glanville's order of June 14 contains a critical error of law. The law requires that when making a determination under that rule, the court must consider whether recusal would be warranted, quote, assuming any of the facts alleged in the affidavit to be true. A judge, quote, is not allowed to pass on the truth of the allegations in the affidavit, end quote. Significantly, the Georgia Supreme Court's denial of Kendrick's emergency petition focused on Chief Judge Glanville's violation of the recusal rules. Yeah, even if Georgia Supreme Court denied this motion, they can still use the information in that denial. And denial was not about you were wrong, it was you filed it to the wrong court. The court emphasized the portion of this rule that reads, if it is found that the motion is timely, the affidavit is sufficient, and that recusal would be authorized, if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. Instead, Glanville properly found that the Weinstein affidavit contains assertion of fact to support the allegation of bias and impartiality, which by law should have ended his inquiry. Chief Judge Glanville must then refer the recusal motion to a neutral judge to decide the merits of the motion pursuant to that rule. Glanville's factual review of the Weinstein affidavit is particularly astounding given that Chief Judge Glanville has repeatedly refused to give defense counsel access to a full transcript of the secret ex parte proceeding. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of our source and to issue an order to show cause to Kayla Bumpus in an attempt to silence her. Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. Glanville has scheduled an in-camera meeting with prosecutors and defense attorney on July 1st. That's on Monday, to review the transcript of the secret ex parte hearing, but it is unclear today if defense counsel will see the entire transcript and what, if any, portion will be made public. Glanville is still indicated that any transcript provided will be redacted to remove, quote, privileged information. What could be privileged in a proceeding among Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. Glanville failed to follow that rule. Proper procedure requires referring a motion to recuse to an unbiased judge after the three prongs of that rule have been met. C. Glanville has violated multiple rules of the Georgia Code of Judicial Conduct. The facts alleged in the Weinstein Affidavit must be assumed true when deciding whether recusal would be warranted. The detail learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least 2.9 of the Georgia Code of Judicial Conduct. Dun, dun, dun. And footnote, and footnote, and footnote, and footnote, which assures every person of a fair hearing. Quote, ex parte communications are presumed to have been in error. Not only did Chief Judge Glanville fail to notify defense counsel about ex parte proceeding as required, but Glanville made every effort to conceal that proceeding. As Attorney Lester Tate states in paragraph 14 in his affidavit in Exhibit C, in reviewing the video of the exchange between Judge Glanville and Attorney Steele, there was no disclosure of the ex parte proceeding, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Georgia Code of Judicial Conduct, this rule, quote, says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Quote, the facts must be considered from the perspective of a reasonable person, rather from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Glanville should not have coerced sworn witness Copeland to testify. Quote, a trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. A few case law. As the Georgia Supreme Court wrote, quote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she, quote, has personal bias or prejudice concerning a party or a party's lawyer. Defendants will not provide a notice of the hearing. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness is in a critical stage of the trial is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Judge Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness into testifying. As the motion to recuse met all requirements, Glanville must assign the motion to recuse to another judge for consideration of the merits. I'm getting thirsty here. How are you all doing? Good, I hope. Hit the like button. Rule 2.1 of the Georgia Code of Judicial Conduct reads that judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. Yeah, he haven't done that this entire trial. In the hearing of June 12th, Glanville failed to follow this rule by failing to make the determination required in a timely fashion. Petitioner need not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12 and 14, were a violation of the Georgia Code of Judicial Conduct. Conclusion. Judge Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. As Attorney Tate writes in paragraph 15 of his affidavit, here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, and who also have actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality and, assuming it to be true, would require recusal. Again, I reached this conclusion based on Glanville's actions, not any ruling that he has made in the course of this trial. Petitioner requests a writ directing Chief Judge Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Chief Judge Glanville to immediately produce an unredacted transcript to defendants of the ex parte proceeding. Petitioner also requests any further writs or orders it deems appropriate given Chief Judge Glanville's action. Respectfully submitted. So these are the first 25 pages. And verification, yeah, this is just mandamus nisi. Now I have unless conditional rule of order of the court. The petition of the Monte Kendrick in the above captioned case having been read and considered, the same is hereby sanctioned and ordered filed, and it is further ordered that the respondent's Chief Judge Oral Glanville appear before me. Oh, this is the suggestion to the judge who will probably be, who hopefully will see this. So this is just their suggestion that a copy of said petition and this order be served upon respondent. Exhibit A is this is a motion to recuse. This is the actual motion to recuse. I've read this before on a separate stream and in a video, I believe, so you can just go look for that. Let's see, Exhibit B, if it's anywhere around here. Exhibit B, Rule easy. This is the suggestion to the judge who will preside, or hopefully will preside. This is the suggested order to appear. Certification of service. And then it's the Weinstein Affidavit. And this we already went through. Let's see here. Exhibit B is another order or motion. And also this is something that we have already went through. Most of what's in here is something we already went through. C is state affidavit of Lester Tate. This I haven't read yet. Comes now as Lester Tate III, personally appearing before the undersigned, and who, upon being sworn, states as follows. He's over the age. Yeah, that is he's the owner of the law firm, Lester Tate Law Group. And as to his experience, this is just him showing to the reader, yeah, I have all the credentials needed. He's licensed to practice law. This is his other experience. But now we get to the meat of the one. While I have not attended any of the trial in state of Georgia v. Jeffrey William et al., Fulton County Superior Court case, this court case, I have watched various video recordings of the proceedings, including the exchange between Fulton County Superior Court Chief Judge Glanville and trial attorney Brian Steele, in which Steele raised the issue of an ex parte meeting with the witness lawyer, and prosecutors. This in-court exchange ultimately led to Glanville holding Steele in contempt of court, an order which has now been appealed to the Supreme Court and stayed pending resolution of the appeal. I have specifically reviewed the order holding Steele in contempt of court and the show cause order issued by Judge Glanville, directing parties to the ex parte meeting to show cause why they should not be held in contempt. Sorry. The opinions I express in this affidavit are based on a review of those video clips and a review of the attacked exhibit. I express no opinion in this affidavit that is based on any ruling made by Glanville. Instead, my opinions herein are based solely on his conduct failing to comply with the Code of Judicial Conduct. Based on the show cause order, it is now apparent that an ex parte meeting took place in Glanville's chambers on the morning of June 10th. This meeting is specifically referenced in the show cause order, in which Glanville directs all participants in that meeting to appear. Since I do not know for certain what took place in that meeting or why it was necessary, I am assuming, for the purposes of this affidavit only, that there was a legitimate purpose for the meeting that is allowed by the Code of Judicial Conduct. Rule 2.9 of the Code of Judicial Conduct recognizes that from time to time there may be need for an ex parte communication. In pertinent part, Rule 2.9 reads, judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or the lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. Exception is 1. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communications, and B, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. This rule, however, also requires in unequivocal terms that any judge who has ex parte contact must promptly notify all other parties of that communication and give them an opportunity to respond. Failure to follow this procedure is a violation of Code of Judicial Conduct, irrespective of the reason for the ex parte communication and regardless of when the contact occurs. In other words, The judge must give prompt notice of communications that happens in trial and in some other context than outside of trial. I would further note that Rule 2.9 has implications beyond judicial discipline. The heading of the rule is, quote, assuring fair hearings and averting ex parte communications, end quote. Therefore, a violation of this rule is not just something a judge could get in trouble for. It is also a rule that assures that the parties to a case get a fair hearing. In reviewing the video of the exchange between Glanville and Steele, there was no disclosure of the ex parte meeting, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Rule 2.11 provides that, quote, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, and who also has actively attempted to conceal the meeting. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true, would require recusal. Again, I reach this conclusion based on Glanville's actions, not any ruling that he has made in the course of this trial. From Lester Tate. Exhibit D, let's see. Oh, this is Kayla Bumpers. Motion to quash order to show cause and motion to recuse this court. Comes now. Attorney Kayla Bumpers, through undersigned counsel, and files this motion to quash the court's order to show cause, filed June 11th, 2024, or in the alternative, moves this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpers shows the following. Recitation of the facts. On Friday, June 7, during the trial, the state immunized Kenneth Copeland and called him as a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th, Copeland and his lawyer, Kayla Bumpers, were escorted to this court's chambers and conducted an ex parte meeting regarding whether Copeland would testify. Those present for the substantive portion of this ex parte meeting was Glanville, Copeland, Bumpers, Adrian Love, Simone Hilton, members of the court's security staff and deputies, 2 investigators from the district attorney's office, and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years, Copeland decided that he would testify. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Now, Kayla Bumpers here leaves out a lot of information. I don't know why. But yeah, so there is differences in the different affidavits. This ex parte meeting was not placed on the seal. There was no protective order that directed the disclosure of these ex parte communications was prohibited. No attorney-client privilege existed. Clearly, as 2 prosecutors, investigators, a judge, a court reporter, and various court staff were also present. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case, who are also with fellow officers of the court. Later the same day, Defense counsel, Attorney Brian Steele, addressed this court to make a record of his due process concern regarding the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. During Steele's attempt to put his due process concern on the record, this court began to focus on the identity of the source who leaked the meeting to defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided the information to the judge, became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. This court sentenced Attorney Steele to the maximum time allowed, which was 20 days to serve in Fulton County Jail. On June 11th, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, specifically Copeland, his attorney, Bumpus, quote, and all representatives of the state and court security personnel that were in attendance, to show cause, quote, why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. No specific names were included in the order, other than Copeland and Bumpus. Argument. The court seeks to hold in contempt the person that leaked the ex parte meeting to defense counsel. Thus, the contempt hearing will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court or committed out of court. My tongue is getting tired. Think of my SO. In this statute, the quote disclosing information from the ex parte conversation to members of the defense counsel occurred not in open court or in chambers, but at the time and location that defense counsel were notified of the ex parte meeting. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Forms of contempt are further divided into criminal and civil, based on the nature of punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court's order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. The contempt alleged by this court of disclosing information from the ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo the alleged contemptuous act, and any punishment would amount to criminal contempt. A. No contemptuous conduct occurred. There neither is nor was anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. To the extent that the show cause order may be subject to a general demur, the order cannot pass this test. Assuming that as true the allegation of disclosing information from the ex parte conversation to members of the defense counsel, contemptuous conduct is not alleged. Furthermore, contempt may be found only where the attorney knows or reasonably should be aware, in view of all the circumstances, especially the heat of controversy, that he is exceeding the outermost limit of his proper role and hindering rather than facilitating the search for truth. In Jefferson, disclosure of the meeting did not exceed the limits of anyone's proper role, and, if anything, the disclosure facilitated the search for truth. A judge may reasonably expect his clerks or other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy do not extend to third parties, not part of the court's staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chamber meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. The show cause order, failing to articulate an act of contempt, should be quashed. This court must transfer this contempt matter to another judge under the procedure for indirect contempt, or alternatively recuse itself pursuant to Georgia Code of Judicial Conduct. Yeah, this is... We read this before. It's about... Glanville did bad. He should recuse himself. Let's see if there are any other exhibits. And she has a bunch of attorneys. Certificate of service. This is the order to show cause. The court has been presented with an issue of contempt for determination. All individuals that were present for the ex parte conversation that took place in the court chambers on the morning of June 10th, to include the witness, Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance, are hereby ordered to show cause before the Honorable Juror Glanville. While one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel, it is further ordered that the failure of any of the individuals who were present for the June 10th ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. Judge Glanville. And Affidavit, Caliph Adams. This is just a reiteration of what happened. So it's just another to boost the other affidavits. And this is the Supreme Court order. I did that in a separate video, so you can read that there.